Call the next case, please. I'm sorry, you already called it. Here's the appellant.
Your Honor, I'm Sharif Gindi, and this is Andrew Beamer for the appellant, plaintiff William Owings.
Good morning.
Your Honor, our condolences to the court. And, Your Honor, if I could, if it's okay with the court, I'd like to have 10 minutes, reserve 5 for rebuttal, and let Mr. Beamer do the rebuttal, if that's okay with the court.
That'll be fine.
Thank you. Your Honors, this is a case, the appellant and plaintiff, William Owings, is appealing from the final order granting summary judgment in favor of the appellee defendant, Reba Owings, by the Circuit Court for Roane County, Tennessee. The single issue here is whether or not that trial court erred in granting summary judgment in favor of the appellee on the issue of liability. Your Honor, the facts, Your Honors, the facts presented in this case were really very simple as far as the facts that were known to the court, presented to the court for summary judgment. There was a car accident. The defendant, Ms. Owings, was driving. Defendant, appellee Ms. Owings, was driving. Our client, Mr. Owings, plaintiff appellant, was in the passenger seat, and she swerved off of the road, hit 2 or 3 parked cars, causing injury to Mr. Owings, causing some property damage, but also injury to Mr. Owings. In depositions, after going back and forth a little bit, it appears that Mr. Owings agrees that, assuming that an animal did jump out in front of the road, that, well, she did what she had to do. It wasn't really her fault. But he goes back and forth a little bit before coming to that. It's clear, though, that under no circumstances was Mr. Owings negligent in any way, and nor did he, was he liable in any way. He's just a passenger in the car. Another thing that's that we hadn't pointed out before, there's no indication whether this was a small animal or a large animal. That might make a difference as to whether or not swerving to miss it makes any sense. There's no indication of that so far. So the trial court found that it was undisputed that an animal ran out in front of appellee's vehicle, and the appellee swerved to miss it, and that there is no proof in the record of anything that appellee did that was negligent. So what we're asking is this court to rule that the fact that a defendant or a defendant purposefully, intentionally swerves off of the road and hits other cars, causing injury, regardless whether or not there was an animal in the way or not, making a decision to swerve, hit other cars, causing injury to her passenger, that in and of itself is enough to create a jury question. Okay, jury, what do you think? Is there negligence here? Is that what she should have done or not? Without anything more. There was no expert testimony as to what she should have done or shouldn't have done. There was no one admitting to, oh, well, I shouldn't have done that or my fault. But what we're saying is you don't need that. I mean, if in a case it's not enough when it's undisputed that the driver, it's a one-car accident, the plaintiff passenger did nothing whatsoever, the driver swerved, even if it's undisputed that there was an animal in the road, which, like I said, I don't know if it was a mouse or an elephant. I mean, probably not an elephant, but, a moose or something like that. So she chose to swerve. She chose to not hit that animal. She made a conscious decision, at least as far as we know, as far as the facts that were presented to this court. We believe that to find that this is not a jury question or question for the finder of fact, in this particular case there was a jury demand, that would create an untenable standard for plaintiffs, barring them from recovery even when defendant's negligence is quite clear.
Did your side in the trial court concede that there was, in fact, an animal that may have ran across the road in front of her?
Did our plaintiff see that? Did the plaintiff?
I mean, with your position that you conceded that there was an animal?
My position is no, that we have not. I'm just saying even if there were. My position is that for sure, the plaintiff said he did not see the animal. The only reason he says that there was an animal is because that's what the defendant told him. The defendant is his ex-wife. They have a on and off again relationship. They went to dinner together, but he believes her that happened. He has no reason not to believe her. And after, that being the case, he says, well, I guess she did what she had to do. It wasn't really her fault. After took him a little bit of going back and forth to get to that, but no, I mean we're not conceding that there was an animal, because we think even if you just take the deposition of the plaintiff, that even from that deposition it's not clear. It's clear that that's what she told him, and it's clear that he believed her, but I think that still leaves a question as to whether or not there was even an animal.
That's not conceding?
Maybe I'm wrong, Your Honor. I don't think so. But I do think, Your Honor, that even if there is... Oh, that he's conceding.
Agreeing to, if she said it, it had to be.
Your Honor, that may be right. I mean, if he's saying, well, she said it and I didn't see otherwise and I believe her, is that conceding? I guess that's probably right, Your Honor. I mean, at least as far as factually, maybe even for purposes of summary judgment. But even that, Your Honor, a jury could still, hearing all that, a jury could say, well, maybe there was, maybe there wasn't. I mean, I don't know what happens when she comes up to the stand and testifies. A jury decides who's telling the truth. So it's coming from her. He thought she's telling the truth, but he's her ex-husband.
Isn't that always the situation in a summary judgment, that the argument would be, well, the jury might, even though this is the only proof on it, the jury might just decide to disbelieve the defendant? I mean, isn't that always the situation?
Well, to some degree, Your Honor, but I think because it's clear that he didn't see it, and the only reason the only proof is what from his deposition. The fact that he didn't see it, and the only reason that it's been deemed a fact that it happened is because he says that it happened, and then we find out that, well, he says it happened because that's what she told him. So I think it's a little bit different in that sense.
Are you saying then that it's a disputed fact whether or not there was an animal in the road, or just the jury may determine it was negligence in any event?
I'm saying both, Your Honor, but I think the first one is not as important to our argument. I'm saying it's a disputed fact in the sense, because even looking at his deposition, like where does that come from? The question at deposition. Mr. Owings, just to clarify that, earlier you testified that you don't think she did anything wrong. Is that correct? Not nothing. I mean, I don't know. No, I'm so sorry. That's yeah. Not nothing. I mean, I don't know what else she could have done. I wasn't in her spot. Right. Animal jumped out. She didn't have any other choice but to swerve. Is that right? I didn't see the animal, so I don't know. I mean, so I don't think it's even that clear that there was an animal. But I think more importantly, let's say that that's a concession. Let's say that, well, sure, I can make that argument about any case that, well, what's the jury going to believe? I think even that being the case, to say that swerving to miss an animal, that that the other party that is sued, that there's no other party involved. There's that could have been negligent, could have caused the accident. There's the defendant who could have caused it, the plaintiff who's just sitting there who's a passenger, the animal who pops out in the way is not a party. She swerves to miss the animal, causes injury. To say that those facts are not enough for a jury to decide whether or not that's negligent is, I mean, like we're saying, that's just an untenable standard. I mean, that's more information probably than a lot of, more, of a concession or more of an agreement as to the facts towards liability that you may have in almost any other, many other cases, car wreck cases. Because, a lot of times there's some question, well, sure, I rear-ended you, but did you slam on your brakes too fast? I mean, there's some, comparative fault in there. Here, there's no place for comparative fault. This is just, what did she do? And I'm just going to I think the rest of it is really covered while we don't think it's act of God or it was an unavoidable accident. But I just wanted to throw in just real quick that in essence, what this would mean is also would be the opposite, would be that not swerving and hitting an animal and therefore causing injury would be in and of itself negligence as a matter of law. I mean, so wouldn't we have the flip side, which would also be an untenable position for the law to be in? And I think I've gone over. Thank you.
You have your time for rebuttal.
Thank you.
We'll hear from the appellate.
Thank you, Judge. Marshall Stair here for the defendant, and I'd like to thank the court for the tribute to Judge Susano. I've known him, known of him my whole life. He practiced with my dad, and I remember as a little boy calling the office and hearing his name. But I also remember when he had his accident and how devastating that was to my parents, and they were really scared of what he was going to do. And I think his story is a real inspiration to us all about overcoming obstacles. By the time I came a lawyer, it was sort of taken for granted his impact, in the courts of Tennessee. But at the time, it certainly was questionable what he was going to do. So, and it's just such a joy to see around town. So I appreciate the tribute to him today. I'll jump right into it. Like you heard, the facts are undisputed. My client was driving the plaintiff home. An animal came in front of her, and she swerved. I don't think the testimony is clear that she made some kind of conscious decision. It was a swerve to avoid the animal.
Did your client see the animal?
Yes.
And that was the proof that was presented below.
Correct. That there was an animal. She wasn't able to identify it. I think it was referred to as a fox or a dog, kind of that size animal. But she swerved and hit parked cars. And so there's not any facts in dispute. The trial court, and there's been talk about an untenable standard. The standard in Tennessee is that the plaintiff has to put on proof of negligence, including breach of duty. That is not an untenable position. And the trial court said the reality of it is there is no proof in the record of anything that the defendant did that was negligent. And that is necessary in order to overcome this motion for summary judgment. So that's why we're here today. There was simply no proof that my client did something wrong. There's no proof that she breached her duty of care. And going back to the summary judgment standard laid out in Rye, there's two ways for summary judgment. You can negate an essential element, but the other way is you demonstrate that the non-moving party's evidence at the summary judgment stage, and in the opinion that's emphasized, is insufficient to establish the non-moving party's claim. And that's what we're doing here. That's what this motion for summary judgment is. And the Rye court stated, the focus is on the evidence the non-moving party comes forward with at the summary judgment stage, not on hypothetical evidence. And that's what that seems like their whole premise of their argument. Hypothetically, she could have done something else. We don't even know what they're saying she should have done to avoid this accident. It's some kind of hypothetical standard that she should have done this. I do a lot of car accidents. Usually, you should have been going slower. You should have yielded. You should have had more distance between you and the car. You should have been paying more attention. There's usually some kind of accusation of something you've done. And in terms of the factual dispute, I think it's clear that the parties agreed that there was an animal on the road. And if you look at written discovery, so this is an interrogatory to the plaintiff. And the interrogatory, it's number 19, it states, state in detail your version of how the accident occurred. not the defendant's version, the plaintiff's version. And this is how the plaintiff answered. The defendant was driving up Route 61 when something jumped out in front of her. I was in the front passenger seat. The defendant swerved to the right to avoid hitting it and hit 2 or 3 vehicles. He signed that interrogatory answer. His attorneys signed that interrogatory answer. So to me, that should make it undisputed. Now, at the deposition, he did say he didn't see the animal. But I want to point to something that's not in our brief, and that's the technical record, page 28. It's page 21 of the deposition. And the question is, I mean, from her actions, did it seem like she was swerving to miss an animal? And he says, I don't know. I mean, yeah, she swerved to miss something. So his testimony is she swerved to miss something. There was something in the road. So I think that's, for purposes of motion for summary judgment, it's undisputed. And he's not saying there was no animal. If he thought there was no animal in the road, he would have answered that interrogatory. For some unknown reason, she swerved into parked cars. He obviously believed her, and that's why he has answered that. The non-moving party under Rye must do more than simply show that there's some metaphysical doubt as to the material facts. And I think the court addressed it. Credibility is not a valid basis to defeat a motion for summary judgment. Maybe the jury will think she's, not credible. And so if you look at the plaintiff's claim here, they're essentially arguing just because she was driving and there was a wreck, negligence is presumed. But that is not the law in Tennessee. And Brackman v. Adrian, negligence cannot be presumed by the mere happening of an injury or accident. And I think that is a key principle in tort law in our state, that just because an accident happened doesn't mean somebody necessarily did something wrong. Oftentimes it is, but there are circumstances where accidents can happen and people didn't do anything wrong. And what's key about this is exactly what the plaintiff believes. The plaintiff does not believe my client did anything wrong. In the deposition, do you think she did anything wrong in causing this accident? No. Well, why did you sue her? Because they won't pay my doctor bills. He's not suing her because he thinks she breached her duty to him. He's suing her because they won't pay her doctor bills. Well, did she do something wrong? No, I don't think she did. No, I don't think she done nothing wrong. I mean, she done what she had to do. That's how the deposition ended. And I think it's unfair to go forward to ask a jury to find negligence when the two parties in the accident, the passenger and the driver, don't think the driver was negligent. This isn't a complicated medical issue. This is just driving down the road. The plaintiff does not believe that she did anything wrong. You don't need an expert. Why would we need an expert to say that my driver didn't do anything wrong when the fact witness, the plaintiff himself, doesn't believe so? I think it's unfair to ask the jury to reach a conclusion different than what the plaintiff reached, and he was there during the accident. I'd like to, and this is in the brief, but bring the court's attention to Jones v. Ray, authored by Judge Susano. And I want to focus on this case because this was not brought to the trial court's attention. We were not aware of it at the time, but it's almost identical facts as this case. In Jones, it was a passenger suing a driver. It was a motorcycle, and they had been hit by a deer. There was a lot of allegations: failure to look out, failure to being inattentive, excessive speed, failing to take proper evasive action, failure to apply brakes. There was evidence put on that the pathway was clear, that the driver should have seen the animal and avoided it. But the court upheld the summary judgment, and they stated, I think the key line is, the evidence simply could not lead a jury to reasonably infer, without speculating, that a reasonable person under the same circumstances should have seen the deer and avoided the collision. And that's exactly what the plaintiff is having, what's going forward here. They're wanting the jury to speculate based on no evidence that my client did something wrong. Coming to that decision in Jones, the court stated they relied on the most significant testimony given by the plaintiff, who stated, the question was, at any point, once the two of you started traveling on the Natchez Trace Parkway, did you feel the defendant was driving inappropriately or dangerously? And the answer was no. That testimony is for all intents and purposes, identical to the testimony from the plaintiff when asked, did you do anything wrong? No. There's testimony on page 27 of the technical record, 20 of the deposition. Did she seem to be going the right speed? I guess. There's just simply no evidence by the plaintiff in an affidavit or otherwise that she was doing something wrong. And just as in Jones, the plaintiff wanted the jury to infer that the driver could have avoided the deer, it's the same thing here. The plaintiff wants to infer that there was some magical way that my client could have avoided this accident, and we don't think that's correct. Really, I feel the standard from Rye is sufficient, and what the trial court found, that there was just simply a lack of evidence of breach of duty by my client. And I think it's important to look at the definition, and that is the core of negligence is the violation of a requirement by engaging in behavior which should be recognized as involving unreasonable danger to others. I don't think they put on any proof that she did something unreasonable. And that's clearly what the plaintiff himself thought, that she didn't do anything unreasonable. We introduced the two other principles, mainly the act of God and unavoidable accident, mainly because I think these are legal doctrines that show that sometimes accidents happen without negligence. And so, are they... I think both of them could be used to support the motion for summary judgment. Act of God, this is something that my driver had no control over. An animal came out into the road, and that's foreseeable. Anybody that's driven has had some type of animal, cross their path at some point. But even so, and the court in Jones addressed that, even if it's foreseeable, there's still nothing in the record that shows the driver did something wrong. Unavoidable accident is the same principle. It's this idea that's ingrained in our system that there are unavoidable accidents. There are accidents without negligence. And I mentioned that, this case didn't require an expert. We certainly didn't hire one. It's not our burden. On page 12 of the appellant's brief, they argue that we have to prove that we're not negligent. That is incorrect. What is correct is the plaintiff has to present evidence that the defendant is negligent. The defendant does not have to prove that they were not negligent. And last, to me, it's unfair to ask a jury to come to a conclusion that's different than the plaintiff. When he was there in the car, that my driver was negligent. He doesn't believe so. He's presented no evidence, no affidavit, no experts, nothing to show that my client did something negligent in causing this accident. So, see, I've got 2 minutes and 55 seconds left, and I hate to, but maybe you appreciate it, but is there any questions the court has on our position? I think it's laid out in the brief as well.
I hear no questions. Thank you. We'll hear from you in rebuttal, counsel.
Thank you, Your Honor. May it please the court, I'm Andrew Beamel, Knox County Bar, and I'm very sorry to hear about Judge Susano. I didn't really know him personally. I know his son, but he had quite the gravitas, and his intellectual abilities were undeniable. Your Honor, just very quickly as some rebuttal, the appellee one of his assertions was, it's so simple, we don't need an expert. And he's right, it would be our burden to get an expert, that's correct. But if if this court was to rule that our client's saying that she said it must be true, it would state that you always have to have an expert. In a one-car accident, how is our client, it defies what it's going past what he says in his deposition. He clearly ruffles. He doesn't know what the truth of the situation is. He can repeat what she says, and he can say, she's generally truthful, but he didn't see anything, and that's clear from the record.
But is there any proof in the record of whether or not an animal came in front of the car other than what the defendant says?
No, Your Honor.
Okay.
But I would state that that's true for many events. I mean, isn't that the old, if you shoot somebody, you make sure you kill them so that there's no other witness. I mean, if you're the one who does something and no one else saw it, it's always going to be your version. That's just, I mean, there could be no other version. There is no other witness. And I would say this is quite distinguishable from, I'm sorry.
If I may interrupt, could you address Jones versus Ray?
I was just about to, Your Honor. And what I was going to say is I think this is very distinguishable. In Jones v. Ray, he didn't swerve. So he's on his act. He's going. Animal one's out, hits him. I mean, I wasn't the lawyer at that point, so I'm not going to say, I might not, I don't know what, but I can say he didn't do anything. They were on the road, they're going straight, hits the animal. This situation, she's on the road, she says an animal ran out in front of her, and I think my counsel is correct. I'm not sure it really, I'm not going to say if the animal did or didn't, I don't think it necessarily matters. And she swerves, and she hits some parked cars. Now, it is I think it's uncontroverted that she has a duty to the passenger. The trial judge never, in fact, in his statement, if you read in the deposition, his statement was that there is a duty here. She is the driver, he is the passenger. So clearly, duty. I don't think there's any. If she doesn't have a duty to her passenger, then I don't know what duty I would ever have to anyone. He has no control over this event. She has complete control. His safety is in her hands. That's just the point of being a driver while driving a car with passengers. It's just how it is. So she's driving, she swerves, she hits parked cars. That's uncontroverted. And it is our contention that a jury, that is a triable fact. Now, we're not saying there couldn't be comparative negligence even, maybe, I don't know. I mean, a jury can make that determination. The trial of fact can make that determination. But to say that there is no contributory negligence, that there is no evidence that she did anything wrong when we have an accident with injuries, with property damages, and the only person's event that we know happens what she says happened, it defies the very essence of, I believe, personal injury. That is what the jury is supposed to hear, is what is these facts. So I think we did assert something that a jury could hear. Now, I understand that we didn't have an expert. And as the deposition makes clear, this wasn't a case for the most damages. And our client this is his ex-wife. He's not seeking to punish her necessarily. But as is clear from his statements in the record, he doesn't know. He is just relying on what she says. And he even says, I didn't see it, I don't know, I wasn't driving. Just to clarify, you testified she did nothing wrong. Not nothing. I mean, I don't know what else she could have done. I wasn't in her spot. It's not his duty also. Now, here's something I think is very important. I have just a few seconds. He's not the one who decides whether or not she was negligent. That is the trial of fact. Saying that his subjective belief is the beginning and the end of the story, I think is not necessarily the most relevant part, especially not to the point of summary judgment. Thank you, Your Honor.
Thank you. Court's thanks to counsel for both sides. We appreciate your argument this morning and your briefs. If you would, recess court until this afternoon, please.
All rise. This court is at recess until 1:30 today.